Then we continue with Carsten Bartholl and André Lippert from the law firm TaylorWessing. We've been working together with the legal working group and Carsten Bartholl since 2014. Had nice discussions. The last year, our legal workshop during the wind energy fair at Hamburg, we didn't realize it due to the Corona pandemic, but I'm happy to see you here and with your colleague André Lippert. You're working on energy issues. You're doing M&A transactions. Your colleague André Lippert is working on regulative issues. Feel free to start your presentation. Thank you very much. You're still muted, Carsten and André.
Always good if someone's watching me. Yes, thank you, Tobias. Good to be part of this seminar. I have the same question as you had, Tobias. How can I start our presentation? Or where?
Sean? Yeah.
Okay. So we in preparation to this seminar, we had started to prepare slides, and we have of course before this had a lot of internal discussions and considerations on what the consequences of the Constitutional Court ruling in Germany would be. Therefore, the presentation is a bit longer, and we will in no way will it be possible to press this into 10 minutes of speaking about it, because there are so many potential consequences, so many things to discuss along the way to achieve the goals of the Climate Protection Act in Germany as it has now been amended. So there will be a slide. We will concentrate on some of the slides. I assume that the slides will be shared and can later be downloaded, so that also any follow-up questions from other slides might be of interest for you, and we will of course be happy to answer whichever questions you may have from that. I would like, with my part of the presentation, I would like to start with slide 6. Yeah, we have heard from Karl about the contents of the Constitutional Court judgment, and we have also heard, I've took some notes, that the court, or that the expectation is that there will be transparent guidelines for further structuring of greenhouse gas emissions, and that the Climate Protection Act shall procure for sufficiently specific orientation. I personally am not so sure and convinced that the changes in the Climate Protection Acts, which have now been implemented or which are now under discussion following the draft from the German government, are really specific enough. What we see here in a bit more detail in the table below on this slide are the targets which are allocated to the different sectors in German industry. And again, they are still only targets. They are not precise measures, and we will come back to this later. And if we had 3 hours time, we would still not even be able to cover all the precise issues that one could think about in implementing these targets in a reliable way. Next slide, please. So what will be, as you may have seen, the largest burden evidently is allocated to the energy sector. And we have already agreed in Germany on phasing out of the use of coal for energy production. We have concentrated, like many other countries had, on rather abstract targets so far. And as I have just said, the expectation is that there must come more concrete measures. However, we have so far not seen such concrete measures on the horizon. There's some discussion about the amendment to the Climate Protection Act, but we have not seen any movement, or I have not seen any precise movement in terms of what exactly will happen. And the energy sector, as a very conservative part of the German industry landscape, the energy sector is in a way left without any solution. They know they have to adopt to the new targets. They know they have to do something. Then the same applies. We have been speaking with the interest club for the German energy consumption industry and for intense energy consumers in Germany. And they are also saying we need to adopt to the change. We need to adopt to the new rules of the market. We need to know how to deal with green energy PPAs, etc., etc. But we don't have the environment. If you look at the last bullet point on this slide, this is a very recent publication I have read in the Internet of Berlin newspaper Tagesspiegel, where the energy industry urges policymakers to say what we need is 300 to 400% more in renewable energy, 300 to 400%. And we do not see that the legislative, or I do not see that the legislative environment in Germany so far has adopted any concrete measures, such as, for example, changes in planning law, etc., to achieve this goal. And this is a goal that must be achieved within a rather short period of time. Next slide. So the result is evident, and there's more or less other words for what I have just tried to say. What is evidently needed is an expansion of renewable energy production. Issues like joining the sectors will play a big role in it. We will hear a bit more maybe from André on, for example, on implications for the real estate sector, etc. But we urgently need much more new production facilities. For example, if you look at the third bullet point on this slide, it is said that what we need in wind energy onshore is five times the pace of newly built capacity compared to what we have now. Luckily enough, we have larger turbines. We're reaching 6 megawatt turbines for onshore wind, but we still use much too much of the time to have them permitted, to have them planned, and I don't know in which period of time erected. So this, I think, these I think are the main goals which have to be solved by policymakers. And again, I personally cannot see too much of this now in the amended Climate Protection Act, nor in other legislative activity at present, which may change once the elections in Germany are through and we have a new government. Next slide that I would like to concentrate would be slide 11, because I think that's individual claims, right? That's an interesting topic as well, and Dörte Fouquet has also mentioned it. How direct individual claims can be tied to the issue of climate change, and the Climate Protection Act, both in its current version as in the intended amended version expressly says that no individual right will be granted by virtue of the code. This is expressly set forth in the draft legislation, so as to prevent private individuals or maybe companies or associations for climate protection, to prevent them from suing governmental bodies or federal states for not reaching the targets included in the Climate Protection Act, which, being honest, makes the Climate Protection Act less of a piece of legislation and more a political declaration. it is still only a piece of paper with targets. And it remains to be seen how these targets will then be implemented by such concrete measures on which project developers, the industry, energy consumers, etc., can really rely on. Interesting in this context is, in fact, the court decision in The Hague. I believe it's now 2 weeks old, where Shell has been obliged, upon litigation initiated by private individuals, to reduce their carbon dioxide emissions. Very interesting case, and from a legal perspective, so far practically unheard of, that in fact a court in a European country awards private individuals a claim against a specific company to reduce carbon dioxide emissions. Very interesting to see that. And if we look at slide 12, this is a citation from a report on the judgment from The Guardian, where inter alia, the court, that's the second to last bullet point, where inter alia, the Dutch court has not only based its judgment on this article of the Dutch Civil Code, which I would not understand if somebody would show it to me, but which has also based it, and we have heard this from Dr. Fouquet in her presentation, which is also based on articles of the European Convention on Human Rights. And that blends into the pending court there at the Human Court for Human Rights, initiated by the Portuguese families that you have mentioned. This will be very interesting to watch, and it will also be interesting to watch how the reasoning of the German constitutional courts will be used in the future to base individual claims of private individuals or of companies against governmental bodies, and maybe even in the longer future against companies to submit and observe climate change rules. So, very quick run through some of the slides from my perspective, and I hand over to André, who will fill you in on some more of the expected outcome and consequences of the Constitutional Court ruling.
Yeah, thank you, Carsten. Okay, André.
Yeah, thanks.
What's yours?
Thank you very much. Thank you for the invitation and for the possibility to be with you here today. As Carsten has already said, I'm working with him especially on regulatory issues on the energy sector, and I've just a few thoughts on our topic. And as we understand it, the main question was the law implications from the ruling of the Constitutional Court. So I prepared some issues, some thoughts we could share and perhaps discuss, and it's only a few minutes. With look time, I see that I only have a few minutes, but I would like to start with the first slide to present our question, which we put at the beginning. Yeah, this, or the second slide. This is on the first. Yeah, this one. It's a really new survey of, you already know, the German Association of Wind and Water Industries, and this survey says, okay, from the ruling of the Constitutional Court, we might see that decarbonization is hitting digitalization. So it was a survey between a lot of business who has been asked what their challenges for the future are, and they said it's no longer, and on the first place, digitalization, but more decarbonization. And this is, I think, and we thought, and we see it already, one of the main points, perhaps a more political point or a more economic point, which are strengthened by the ruling of the Constitutional Court in Germany. There are 2 points at the end: long-term PPAs and guarantees of origin. This is very interesting because the surveyed business said, okay, two very concrete issues are of shared or important interest for our business model, and this is that long-term PPAs, from which we can get our electricity, green gases, will be more and more important, and as well, and this is very interesting for us as well, these guarantees of origin, which are the means to say that electricity is from green sources, will become more and more important. And I think these are 2 very concrete outcomes of the ruling, which are strengthened by the ruling. And as I already said, these long-term PPAs are not only for electricity, but as it said here, for green gases. And perhaps we can jump to slide number 9. Another, and this was my understanding of the task, another concrete idea which we have is that the ruling of the Constitutional Court will give wind, will promote the discussion on green hydrogen. The thesis we put there is that the expansion of the use of hydrogen is very at stake, is discussed widely, but the future challenge is to come from the pilots which are launched to the market launch. This is one thing, how Carsten had already said, the problem is that the targets are clear, but the means are still missing. And one of the means which we think in the future will be discussed more are these hydrogen expansion. There are some figures which we took on the slide, but the challenge is on the last box. And it says the challenge for the legislator in Germany and worldwide and European legislator is to create a legal framework that is safe and which provide a reliable basis for investments and to promote the market launch. We have a lot of pilots now, and we have a lot of 8 billion euros were granted by the German government a few days ago for this important project of common European interest. But we are still looking at the market launch in this area, and now we're discussing some kind of voluntary opt-in regulation for hydrogen networks. This is one issue we are just discussing, or the EEG levy for electrolyzers. And we can see here that this decarbonization issue will be of more and more importance if we look at the implications of the constitutional ruling there. Another issue, and this is only one aspect I wanted to mention at the end, is on page or on slide number 12. This is not a first step. This number 12, the one with impact on environmental building and planning. Yeah, this one. Thank you. This is not at the first resort a question of energy law, but we see in Germany, as we discussed it in Europe as well, that it's especially the building sector who does not fulfill its requirements in the last years. We have I mentioned the German name there, the building energy law. This is a new law, and there have been a lot of discussions in Germany because there are no stricter standards compared to the preceding regulations. And this is astonishing because it's the building sector who is responsible for most of the greenhouse gas emissions, and it's the EU, it's in the last box, who has adopted a renovation wave strategy and is on the way to promote new regulations. But we are still discussing the concrete figures for the building sector. And my forecast is that this is one of the sectors who will face a lot more of restrictions in the future to meet the requirements which the Constitutional Court has mentioned with regard to decarbonization. On the last, and this is just to mention the last two slides. I'm not quite sure the last three. It's beginning with the next slide. Yeah, 13 on my. Perhaps you can see the next slide. Yeah, this one and another one. You can go on with what is expected. We have just gathered, and you can read it after our presentation. We have gathered a few examples of what is just right now discussed to meet the requirements of more decarbonization. And there are a lot of proposals from the different stakeholders, but this is, as I already said, one you could have a look into after our presentation. We just wanted to have a quick look at some of the issues discussed after the constitutional ruling, and that's what we wanted to discuss. And perhaps if there are any questions, please feel free to ask them. Thank you.
Yes, thank you very much, Carsten and André, for this presentation. I think we will upload the presentations on the website of the World Wind Energy Association so that everybody has the possibility to check this out. Yeah, thank you. What I really liked in your presentation was the hint that it's good to take legal action, but then in the second step we have to define how we reach the targets. And Carsten and you showed it that we need legal action for renewable energies, and then also hydrogen is quite interesting to fulfill the CO2 reduction. Yeah, and I think that's also up to us as the World Wind Energy Association to make proposals how we can reach the goals and how we can reach the CO2 emission reduction. Okay, thank you, Stefan.
Well, let's have a look at whether we have any questions to our legal experts here. And I see there was one that hasn't been answered yet from Sain that is related to the German case. And I would request some of the German experts we have here, whether anyone is prepared to answer that. Does the German court's judgment imply a probable tortious liability and a revised standard of duty of care for private companies if emissions traceable to them are out of sync with CO2 limits? Is the judgment restricted in scope to greenhouse gas, or in your reading can it extend in principle to other pollutants not directly related to global warming but tied to other ecological impacts such as on water, vegetation and wildlife? Any such litigation in the pipeline to look out for? There's a lot in this question, and is there anyone, Tobias, Carsten, André, maybe Dörte, who would like to? I'm not sure. I'm sure not answer this completely, but comment.
Carsten or André, do you want to give your view on this topic, or?
I can.
Please.
Let me see if I can look my face in the camera. I can only provide the very high level comment, and nothing even close to a solution. I personally strongly doubt that we will, at least in Germany, we will in a shorter run see many possibilities for bringing individual claims to courts and successfully. As I said, it is not by accident that the Climate Protection Act expressly says there is no individual claim under the Climate Protection Act, and you would have we would have to take each individual measure that you're thinking of, and even more so if you look at the protection of species, you would have to take each and every individual measure through the whole chain of legislation, which can take years and years and years, and you will probably only have a judgment that you can then maybe bring to the Constitutional Court once the time period provided for in the in the Climate Protection Act has expired. There will be, in the current legal environment, I think it will still be very, very troublesome. Although, of course, nobody really, well, nobody is, that's a big word. But I think very, very few people had really expected the Constitutional Court to be so clear in its judgment. But I do not think, I don't know, André, what's your opinion on that? But I don't think that this already means that under applicable German law currently, you have an individual right to receive climate change protection as an individual person.
Yeah, that's absolutely what I see as well. We discussed it in advance, so that's absolutely right. And we have to keep in mind that that the ruling was from 2030 onwards, so it's in the future, and the question of individual claims is one of the important questions from the legal perspective in this case. So I absolutely agree. Yeah.
What I could imagine is that the revision of the Climate Protection Act would yet again be considered unconstitutional on account of its being so vague. As I have shown in my presentation, there's a table of certain reduction targets being allocated to certain industry sectors, but evidently that's not concrete. That in itself does not help to reduce carbon dioxide emissions. How could possibly the energy industry reduce carbon dioxide if they are not permitted to erect sufficient on and offshore wind capacity and sufficient solar capacity, plus hydrogen and all the other items that will play a role in the mix? That's just not possible to do.
Yeah, we have also a participant, Mr. Franke, Johannes Franke. Would you be able to give your short comment if you want? We've been in contact last week or 2 weeks before, and you worked with Roda Verheyen, and you told me an interesting information about the case against RWE. So please feel free. It would be a pleasure to hear your opinion about this suing companies. You're still muted.
You're not muted, but we still can't hear you, unfortunately.
No?
Yeah.
Yes.
Yeah? Okay, so it was just the microphone. Yeah, I can certainly comment on this. As Tobias said, I worked a bit with Roda Verheyen, so I have a bit of maybe a different perspective. I am a bit less pessimistic about potential tortious liability, because that is what the question was. Like, tortious liability in tort law needs to be distinguished from the climate statute itself, I believe, because that, as you rightfully said, excludes any individual rights. However, it's another question if there can be a private liability under general tort law, as it was assumed in the Shell case just a week ago. This is an argument that you could also make under German law, because here as well we have open standards in tort law, which we can try to use in order to argue a private liability, basically using a similar approach as the Shell case did, and the court followed that, as we know. So I'm a little bit less pessimistic. However, I do believe that the judgment of the Constitutional Court does not give us too much in this direction, because the arguments of the Constitutional Courts, they do not argue with the duty to protect, but with the how do you say, with state measures that will come, that are that need to come in order to comply with the Paris Agreement, and that will will impede our liberties here in Germany. So that argument does not really fit to a liability of private corporations. However, what it does say, and this would be a factor that one would have to include when considering whether there is private liability under tort law, in my opinion, is that there can be no trust by corporate emitters anymore, in that they will continue to be able to emit like they do right now, because the Constitutional Court said very clearly that measures need to be taken for constitutional reasons. And although those measures are very unclear right now, I completely agree with that. They still need to come. It's a constitutional duty to take those measures, and that undermines any trust those companies might have to pursue their business as usual. And that might be an argument from the constitutional case that might be used in tort litigation, in my opinion, but I'm speaking from the top of my head here. This is obviously a very difficult question, $1 million question, so to say. Okay, that would be my my comment on that. Thank you.
Yeah, thank you. Johanna, thank you for your opinion. Good. I think we tried to answer your question. Stefan, please go on.
Yes, I think indeed that was very good also to hear these opinions here. I think that's exactly why we wanted to have this webinar, of course, to have such exchange here. And what we understand is that indeed this is just obviously beginning, no? But it seems to be getting a new momentum all over the world. No, maybe not all over the world, but in many parts of the world. And that now leads me to our final speaker for this webinar today.